Romania. Okay, I think we have the green light to start the session, and I believe it's now being recorded. So first of all, afternoon everybody. Welcome to this webinar where we'll be discussing the course on UK and US corporate law. My name is James Hayne Cole. I'm an English qualified solicitor. My background is in competition law, in particular competition litigation, but I have about 10 years experience in all fields of competition law. So that's from mergers, but well, that was a long time ago, behavioural investigations before the European Commission, the UK Competition Authority, and multiple competition authorities elsewhere, including in the US and in Asia. My main focus now is competition litigation, which mainly focuses on claims arising from the decisions of national and international, in the case of the European Commission, decisions against cartellists, and the litigation that arises following those decisions that then leads to reclamaciones, I was about to say, to claims before the English courts and other courts in other European jurisdictions for damages for the people who have been affected by those cartels, so price fixing cartels, etc. I started my career in London with Freshfields. I then had 2.5 years at Cuatro Casas here in Madrid, and I'm now working with a firm in London, Scotts & Scotts. So that's a bit about me. I'll pass over to Lucia to tell you about herself.
Well, first, thank you so much for joining us, your interest and your time. Hopefully this proves useful, and if you have any questions, I'm not sure we can hear you, to be honest. I've never used this program, but I'm sure we can read you. So feel free to do any questions you may have about what we're speaking or the course per se, and we will be more than happy to respond. Regarding myself, I am Lucia Goy. I am a New York, because as I'm sure you're aware, US is a state. So I'm a New York qualified lawyer and a Spanish qualified lawyer. I'm specialized in tax, especially in international taxation. I started my career, well, first I studied here in Spain at ICADE, and then I started at URIA. After URIA, I did my LLM at Harvard and specialized in international taxation. I passed the bar, the New York bar. Then I worked in New York, first at Davis Polk, an American law firm, and then at Skadden Arps. After 5 years, I came back home in Madrid and I set up my law firm, which is a boutique in tax and immigration law. Although we now practice only Spanish law, the vast majority of our clients are American and Latin American. So we're very used to international taxation issues. Anyways, that's a little bit about my CV, and we are very pleased to have you. And in this, I think we can, if James is fine with it, we can go ahead and.
Yeah, absolutely. So we thought that the most kind of enlightening and helpful way that we can tell you about the course that we're going to be teaching this, or in fact next calendar year, I believe it's from late February onwards, is to do through the kind of the spectrum or paradigm of a case study. Now, the case study we have in mind is a merger or an acquisition, because we think this is the best way to touch on the various elements of the course, which, as you will have seen, hopefully from the promotional materials that Complutense has sent so far, is structured in a way where we will basically run through different fields of law, from the way the court systems work, a background in common law generally, to the more specific fields of law, so be it tax, employment, corporate, antitrust, that kind of thing. And a merger is the best way to basically structure it, so we kind of touch on all of those matters in one session. As Lucia said, I mean, if you want, make it as interactive as possible, then please write us questions as we go along, or we can respond to questions at the end. However, the session works and how it flows, basically. So I think another reason for us choosing this merger kind of case study is because it really, I think, hits on the three elements that I think Lucia and I want to come through most in this course, and that's to make it as practical as possible for all of the students on it. I mean, it's one thing sitting back and having a theoretical session, but really I think it's important to us to make the course practical so that you can actually understand the real issues at play as a junior lawyer when you become involved in this kind of in corporate law, basically. So as I've said, the course is structured around the key legal areas, what we see as the key legal areas. Almost in a way, it's structured quite similar to how I did what's called my training contract in England, whereby you sit in a law firm and it's different to the Spanish system. You enter, having gone to law school, you do 2 years as a trainee, whereby you pass either every 3 or 6 months to different departments. And then you do corporate, real estate, employment, and then at the end of that process, you choose what you want. So I suppose, as an English qualified lawyer, I see this hopefully as a sort of microcosm course in a mini training contract, giving you a sort of flavour of each of the different fields of law. And the final and really important thing, I think, for both of us is to promote kind of commercial thinking and commercial awareness in the students who attend the course, because we want at the end of it for you to have a real practical idea and to be thinking not just stuff as a black letter lawyer, but rather as a commercial lawyer who can really think through the practical elements and start thinking, putting yourself in the shoes of your client and how best to serve their needs by the application of law. And the best lawyers, I think, are the most commercial ones. So that's kind of our idea about how this session will work. We're going to take you through an idea of a merger through what is going to be a merger between two hotel groups, a US hotel group and a UK-based hotel group, to give you that international element. And this particular merger, I think, works nicely as a private acquisition. That is, the company that's being bought is not listed on the stock exchange in any jurisdiction, but rather is a privately held company. And we can work through the various kind of practical elements of that. So that's the kind of background to today and our thinking on the course. But generally, I think Lucia is going to give a kind of overview about the areas we're going to touch on in the webinar.
So have we discussed about the actual names?
Yeah. So
the main points we're gonna touch on and explain, and which would be the main points that you would need to consider in an M&A transaction, can be separated in 5. Obviously, within each of them, there's plenty more, and there may be more, but we think these are the main matters that should be taken into account in an M&A transaction. The first, the deal structure, and by deal structure, James will enter into more detail, of course, but deal structure, are we acquiring the shares, are we acquiring the assets per se, are we acquiring the line of business, etc. So what exactly, from mostly a corporate point of view, are we transferring? Then the physical assets that are being transferred, obviously is not the same to be transferring real estate, or to be transferring employees, or to be transferring goodwill. So, and that has different implications, legal implications, liability implications, and obviously tax implications. Then the third point, more and more important every day, the IP, intellectual property, the assets in that company, the IP, who has the rights, if there may be any liabilities, any potential risk. Well, a potential risk of litigation may be in any, of course. Tax implication, this obviously for me is super important. What taxes are going to be triggered, which country, which location, what are the risks, can this be understood by the tax authorities in another manner? Where is the tax going to be triggered? Not by the seller, by the buyer. Can we do any tax planning without incurring any liabilities? And what are the options? Sometimes one option is option A, that is better for now, but maybe less beneficial. For example, what taxes are we triggering? No, are we triggering corporate tax? Are we triggering capital gains? Are we triggering VAT? And in order to have a 360 global view of the tax implications for the buyer, for the sale, and all the taxes involved now, and the tax implications for the future, such as transfer pricing, related party transactions, etc. And then the last big point, which obviously James is a big expert here, the antitrust competition considerations. When we do this M&A deal, are we triggering any risks in non-compliance with competition law?
Yeah, exactly. So, to enter into the kind of detail now, so I mean, thinking about the deal structure, this is something that at the start of any transaction is really fundamental to the commercial thinking of the parties involved. So in our example, we have a US hotel group, as I said, seeking to purchase a UK hotel group. Now, there are multiple considerations that the parties will go through at the start. You know, obviously you're thinking about the asking price, you're thinking about what exactly you want to buy. But from the legal side, you need to be thinking about, is this going to be a share sale? Is this going to be an asset sale? So a share sale is where the company that is purchasing in our case, the US company purchasing the UK company, are you buying the share capital? Or in fact, is what you want the assets of that particular business? Now, in many instances, a company purchasing another company will actually not want to purchase the full company itself, but rather pick off key assets. So that could be the case in, for example, in construction, where in fact what you're buying is a fleet of vehicles or access to mining rights, for example. Whereas in our case, the way that we're going to structure this is a hotel group is buying the share capital of another hotel group. So typically that's where the share capital is either existing in one company that owns several companies within a group and the assets within that group, or you could have a situation where you are actually starting a completely new company, and this is very commonly the case, to be the vehicle for that transaction. So you create a completely new company, the share capital of that company is offered to the buyer, and then that company sits at the top of the pre-existing corporate group, and all of the business moves over because of that top co or that top operational company that is being used as the purchase vehicle for the transaction. So, I mean, one of the main advantages of a share sale is that by buying all of the shares within a company, you are buying the entire going concern of that company. So that involves all of the property, all of the things that Lucia just mentioned, basically. So you're talking about physical property, you're talking about intellectual property, you're talking about employees. Everything that you can imagine as a business, as a going concern, will move from one company to the other. Now that has a big advantage because you don't have to tie up a load of loose ends of moving assets from one place to the other. Rather, you buy everything as a kind of a group. So that's a kind of major advantage in terms of the shares. A potential disadvantage, of course, is whilst you're buying all of the good stuff, in inverted commas, from that company, you're also buying all of the liabilities. And we'll come on in a minute to talk about what that looks like from a lawyer's perspective if you're buying a company which has liabilities, potential tax liabilities, potential litigation liabilities. There are a multitude of liabilities that will need to be disclosed through a good due diligence process in order to make sure that what the purchaser is buying is what it thinks that it's buying, and that the risk is kind of minimized to the extent possible. So, as I said, whilst we're talking about a share sale in this context, just to cover off what an asset sale is. So, as I've said, an asset sale is where you are literally just buying one particular part of a company, whether that be tangible assets like construction equipment or intangible assets like intellectual property. Now, a key element of that is that you know exactly what you're buying. It's a more limited pool of assets than buying an entire business, and theoretically it should be rather simpler to figure out the liabilities that are attached to those particular assets. But of course, a major disadvantage of an asset sale is the flip side of the advantage of the share sale. In the share sale, you're literally scooping up everything that goes within that corporate entity, transferring it over to your side, and that could have potential implications in many aspects, which we'll touch on in a minute. For example, in the context of employment, in a share sale, the whole of the employees pass over as part of the one company to the other, whereas in an asset sale, what you want to do is actually buy the employees and that part of the business, there could potentially be quite a lot of issues in terms of reporting. There are statutory requirements in various countries which mean that you have to, for example, undertake negotiations with trade unions, and you have to go through statutory transfer regimes. TUPE is the one in, or 2P is the one in England. But as I say, we'll touch on that towards the end. So those are the two kind of, as a deal structure generally, those are the kind of some of the first considerations. Is it a share sale or is it an asset sale? I've just mentioned, of course, the creation of a new entity, and Lucia is going to touch on that now.
Usually, when there's an M&A, a new holdco is created, a new company, which can be the company that acquires the assets, as James just explained, or a company that acts as a holding company that acquires the shares, and the target becomes a subsidiary, and maybe also it merges within a new company. It's quite common this to be done, first of all, because it is like a cleaner slate, and second, also the tax implications. Usually, when there's a new company, there's a reorganization, and it also means, we will get into that later, that it's more probable that you can qualify it as a reorganization, which in the majority of the jurisdictions, it's the tax is deferred. Spain actually has a very similar regime, and the tax is deferred also if you qualify for reorganizations. In the US and the UK, it's the same. When this company is created, it's that there's three main things to consider. First, the location, which has regulatory, it has tax implications, it has mercantile implications, which we will get into, especially the tax ones later. It has the legal implications of what type of entity I am going to register as. So if, for example, in Spain, SAI, STL, what are the implications of this? Which are the requisites in order to obtain this? For example, can I have all foreign participations? Can I have all foreign shareholders? Can I have all foreign directors? Do I need a local representative, etc.? And the third point is, what tax regime am I going to request? There's some holding companies special regimes which can be maybe very beneficial, or you need also to consider what does where the assets or the activity is being carried out, do they allow you to apply that benefit or not? So that is more or less the matters to consider when creating a new company, and if creating a new company, or maybe you want to stay with the previous company.
Yeah, exactly. So, I mean, and Lucia will touch on this later when she talks about tax implications, but you'll find a lot of companies that are set up as the holding companies are in tax havens like the Cayman Islands, like Jersey and Guernsey, the Channel Islands in England, well, in the UK. So from my experience of English law, on almost every type of this kind of transaction involves a Jersey or a Guernsey company, basically, for tax purposes. So one factor that comes into it, now you've got your purchase price, you're going to have a share sale. The US company maybe sets up a Delaware company to be the new holding company, or a Cayman Islands company to be the new holding company. You need to think about the topic of foreign ownership restrictions. These are the kind of side issues that aren't necessarily at the front and center of the client's mind when they're doing these kind of transactions, but you need to be very careful. So some of you may have seen, if you follow the investigations that are going on to TikTok, for example, in the US recently, there have been problems which have been raised by various government agencies and the Trump administration in the US about the fact that TikTok, which is operational, of course, in the United States, is owned by Chinese companies. Now, because of the way that the TikTok app works, there have been some concerns about the fact that this Chinese ownership is actually a threat to national security in the United States. And you do see these issues raised in large transactions from time to time, particularly, it must be said, in the current climate, if there's a Chinese or a Russian company involved. That depends obviously on which jurisdiction you're in. For example, if if there was a Middle Eastern company and the transaction was in Israel, there'd be issues, I think, with national security around, for example, if there were a Saudi company involved. So those points go a bit more to kind of global and geopolitical questions rather than necessarily strict legal questions. But there are foreign ownership restrictions. That is the kind of thing that the person, the lawyer advising the client needs to be raising at an early stage, because that will go to how the deal is structured. So, for example, in the TikTok case I just mentioned, as a part of a restructuring that's taking place post the transaction in the US involving TikTok, TikTok is going to have to set up a US entity and have greater presence in the US as a part of effectively being licensed and allowed and permitted to operate by the government. So that's a kind of side issue. A real core issue is, of course, how this transaction is going to be funded. It might be that this US hotel group has so much capital that it doesn't need to raise any further money, because it can just purchase this UK hotel group outright. Now, in reality, that's very unlikely, and a company would not generally take on, even very large companies would not take on that kind of capital risk, because they don't want to risk their money in the bank when they can get it from different sources. Now, those two of the main sources that tend to be involved in these kind of transactions are traditional debt finance, where you go to a bank, generally speaking, or historically, traditionally speaking, and you get a loan to effectively pay for the transaction. That has, as I said, capital requirements, kind of implications. Companies are generally happier to take on debt because it means that they aren't threatened in terms of their cash flow. So most companies want to have a good core of capital, money in the bank, essentially. And so if you can borrow, it's like any of us buying a car or whatever else we want to buy. If you can get things through debt finance, it tends to work out cheaper, even if the interest payments mean that, of course, the sum you end up paying in the end is quite high. So on the one hand, you have debt finance. On the other hand, you have equity finance. Equity finance is raised generally through the issuance of new shares in an existing company or shares from a new company, and you sell those shares, you make money. This generally, it tends to be more important to publicly listed companies, so companies that are listed on the major stock exchanges throughout the world. You get, and we'll deal with this in the course, you need to get permission to issue those shares. There are regulatory questions to be considered, but you make your money by basically selling more shares in yourself. That means that the value of the shares in your company potentially may diminish, but it means that you have an injection of capital in your company, which allows you to do a transaction like the one that we're discussing today. A third avenue, and which is potentially linked to the first two, is the possibility of a private equity involvement in the deal. So whether that's a private equity company or, in some instances, a hedge fund, where you have a company which has a massive amount of money because of either the money it has itself or money given to it by investors. Is generally the case that the private equity and hedge funds work. And those companies but effectively invest in this transaction. But the very big difference, generally speaking, between a company doing something of its own accord and the involvement of private equity is the company will have quite a long-term vision. So the company will be doing this transaction. So the US company wants to buy the UK hotel chain because it wants to expand its footprint in the UK and Europe, potentially. Now, a private equity group will be interested also in that kind of growth, but their involvement will be actively more short-term. They will want to pump money in at the start on their own terms. But what may happen in 3 to 5 years' time is that they want to basically realize their investment. They want the value of the hotel chain to go up, and they will then sell their share or their investment in the company to the highest bidder. So the different kinds of finance that's involved in these, and in these major transactions, international transactions, you'll generally have the two parties, their sets of lawyers, and then the bank and their set of lawyers involved as well. And that goes to everything from the sale and purchase agreement to separate debt finance and equity finance terms. So that's something to be considered. Just to run through some of the key documents now. So we've got our deal in place. We know that, for example, the US hotel chain has set up a new company. There aren't any foreign ownership restrictions because a US company is not really going to have problems in the UK unless it has some kind of secret ownership behind it. We want to have debt funding in place because we know that we have the revenue streams that will allow us to pay off that debt finance. And now we need to get to the real sort of nitty gritty, if I can use a British expression, of the deal. So the key documents to start out with, you are going to put your terms of the deal which have been put together between the parties into what is called generally either a term sheet or a letter of intent. Now, the letter of intent is a kind of early contractual document that sets out the purchase price, any adjustment to the purchase price, for example, because of mechanisms about how future performance of the company goes. So for example, you might have a provision whereby the share price, the purchase price is adjusted depending on various steps in the transaction or future things, as in future events. The types of warranties and indemnities that are given, and then things like any non-compete covenants that might be in place that you want. Letters of intent also tend to involve a kind of indicative timetable for the deal. So the letter of intent you can kind of see as a sort of action plan for the deal, which contains the main terms. Now, generally speaking, you might also have kind of things like exclusivity agreements. So the UK company might be selling to the US company, but actually there might be a Russian company involved. There might be a competitive bidder from, whoever knows where. So if the US company is the current favorite, they may insist on having an exclusivity agreement, which gives them, for example, X number of months to get the deal done. Otherwise, that the exclusivity period expires and other bidders are allowed into the process. You might also have a non-disclosure agreement. If it's a more secretive transaction that's going on, you may have a situation where the seller doesn't want the market to know about it because there could be issues with competition, there could be issues with a multitude of commercial reasons why the UK hotel group does not want the market knowing that this transaction is going to happen. So letter of intent's in place. We then start drafting as lawyers the sale and purchase agreements, and that contains all of the key terms. So the conditions precedent. So what might one need as conditions precedent? These are the conditions, the boxes that have to be ticked before the transaction can progress. So shareholder approval, for example, that there's been no material adverse change since the terms of the agreement have been reached. The approval of competition authorities might be necessary. There's no point in you entering a deal and then your deal is shot down by the competition authority, which we'll touch on later. You might have a condition precedent that goes to the tax clearances that are needed or reorganizations of the target business. Things like that will need to be taken into account where they are kind of make or break for the deal to progress. Those things have to be ticked off, otherwise the deal falls apart. You might then have warranties and indemnities. So a warranty, as you may know from your normal kind of interactions with companies as a consumer, is effectively a promise from a company that says, this is true at the date of signing, and then you have an indemnity potentially in place to say that if this promise is not correct or this doesn't hold true, then at the end, at some point in time, we will indemnify you, we will pay you because of this promise being broken. So there may be, in terms of warranties, there might be limits on time, so that this warranty is only good for X number of years. There may be de minimis levels that are reached, so there must be some level of importance placed and a de minimis threshold passed before the warranty becomes active, and the party in whose favour the warranty is has the ability to act on that warranty. You might have provisions about how to conduct disputes, should disputes arise, and you might have kind of obligations to mitigate any loss suffered. So that's kind of broadly the considerations that we'd talk about for a sale and purchase agreement. There might be other documents like stock transfer forms, new employee contracts, necessary board minutes that are required to get approval from regulatory approval from the kind of the local or the European organization that's involved. But that's generally the kind of the structure of the deal points that I wanted to raise.
So the second big part we're going to talk about is the tax and assets and tax planning. Obviously, with myself as a tax lawyer, we are the last ones consulted, and usually the people that break the deal. So I always suggest to my clients to start with the corporate, but at the same time start with the tax, because a profitable transaction may seem less profitable if a big tax payment is due. There's three. I would categorize three things to look into a tax in tax planning. First, taxes from the seller and from the buyer. Obviously, it's different parties and they have different interests, and usually, they don't go hand by hand. The second one, if we're talking about indirect or direct taxation, so indirect, obviously, capital gains, personal income, and corporate tax, and the indirect VAT or sales tax, if we're talking about the US, and stamp or transfer tax, if it is applicable. And the third thing that matters, or the big bucket that we need to look into, is what are we actually transferring. Going back to the initial part of the presentation, which James was talking about, if we are selling shares or we're selling assets, has a big implication in tax liabilities. In general terms, when you're selling shares, it's usually the tax impact is lower. When you are selling assets, the tax impact is usually higher. Obviously, this is a very general generalization, sorry to be redundant, but in both jurisdictions, this is, and Spain also, to be honest, it's usually the case. So going back to the first category, taxes from the buyer and taxes triggered for the seller. So if the seller is selling the assets, let's think that the seller is the owner of Company A. Company A sells the asset to Company B. So first, Company A is going to pay corporate tax for this is in both jurisdictions. If there's a difference, I will always let you know. I'm talking about the general things. So for seller, sorry, if they sell the asset and their valuation in books is 10 and they're selling it for 20, they will have a corporate tax of 10. And then they will need to make a distribution to get hands on that money. So for them, it's usually, in general terms, it's better to transfer the shares, unless obviously they want to keep with the business, etc. If they're transferring most of the assets, because there's only one level of taxation, okay? And there's no two levels, and it usually allows you to bigger tax planning. Also, we need to take into account participation exceptions, etc. That in the European Union, there's a directive of the parent subsidiary, that any company that has a 5 or 10%, it depends on the country. In the UK, it's 10%, and you've had the shares for more than 1 year, capital gains and dividends are exempt. So usually holdcos, if they sell a subsidiary, capital gains will be actually they will not trigger any taxes. So that is very important, and that is a very common structure used in European holdcos and group structures. For the buyer, it is actually they needs to take into account that once you transfer, there's an advantage of transferring obviously the assets at a lower value because you're paying a lower price, but there's also an advantage of stepping up the basis. Why? Because usually in goods that you depreciate, you want the basis to be very high in order to be able to amortize or depreciate and be able to deduct that cost in future. Whereas usually where the most companies have more and where most of tricks are done and what our tax authorities look at more, because it's very difficult to value, is the goodwill. In UK and the US, usually you can depreciate goodwill, which means it invites to a little bit of manipulation. So this needs to be valued at a very honest valuation. Real estate usually can be depreciated and amortized also. This is when you're obviously selling the shares. If you're selling the assets, if you're selling the share, that's a little bit more complex because you have shares and you don't have assets to depreciate. Another big thing, so that is by buyers and sellers. Then what from both points of view, you need to also take into account if there's a reorganization. What does this mean? Usually, there's a reorganization when the person buying is still involved in the company. because if not, they're selling out. So if company A and company B merges and they get shares of company C, that is our organization. The closer we are to our organization, which necessarily means that the person selling is still in the company or was linked to the company in a certain matter, then there's a tax deferral, and nobody pays the rent of the organization doesn't trigger any corporate or personal income tax for those shareholders. So usually, if we can do our organization and comply with the requisites, UK and US both have different requisites, but in the same line, that there's still one of the two parties still maintains control, that they're still involved in the company, that the person remains in the company for a while. Those are the main ones. Obviously, each country has their different details. So if we can comply with that, it's always better to try to do reorganization and we defer tax. That means that you don't step up the basis of those shares; they're still at that value. But when you sell out, then you will trigger tax for the original basis. So if it was at 10 and the valuation as of now is 50, you will be, and you sell for 100, you're going to be taxed from 10 to 190 instead from 50 to 100, which is 50. But you're deferring the tax, which is always better than paying now, no? That is linked to how are we doing this transaction? Are we doing it as a sale of shares, or are we doing it as a sale of assets? If we're still selling assets, it's very difficult, or it's a lot less probable that you will be able to qualify this as a reorganization and to have a tax deferral. So in general terms, just so you have the general terms, assets, no tax deferral. Reorganizations, which necessarily mostly all the times means a share purchase, we can apply the reorganization and tax deferral. Okay, and then the third big bucket is the indirect taxation. Again, this is very important if we're looking at shares or assets. When there are shares in the European Union and the US, there's no VAT, there's no indirect sales tax, indirect taxation. This is in the European Union. This is because of a directive, of the VAT directive, which is a European directive. Obviously, UK will leave the European Union, but I highly doubt they're going to apply different rules for this. And then there's a stamp duty, which in the majority of cases there won't be any. This is when we're talking obviously about shares. When we're talking about assets, we need to look at the regulation. In the US, we need to look at the state regulations because it's sales tax, which is regulated by each state. Really important in the states. The actual states have a lot more powers over taxation than in the UK or in the regions, or Spain in the Comunidades Autónomas. They are practically mostly independent in the majority of taxes. Even they have the same general terms, the same general structure. But for example, in Spain you have, I'm comparing to Spain because I'm sure you're all aware, in Spain you have the IRPF, the personal income, which the communities have a little bit, but but more or less the structure and the definitions and the deductions, there may be additional, but the definitions are the same. In the States and the US, they can actually have different definitions. So that's very important. So the sales tax in the US, VAT in the UK. No, not for shares. For sales, we need to look at the transaction in detail. Usually, obviously, it has a lot of requirements and a lot of detail to be involved. But when you're selling assets which form themselves, all of the assets can be understood as a business unit, which could be a different corporation, and you just have it. You have everything in the same company, but it's actually 2 or 3 companies. Usually, we can try to avoid VAT or the sales tax. This is it needs a different, a particular study, of course. Another big point, these are the main considerations from a general point of view. Then if we get into more specific terms of an M&A deal and where, for example, we were talking about where locating the company, As James well put it, in most transactions, there's always a holdco that is in Jersey for UK, in the European Union, it's Malta, Cyprus, in America, it's BVI, Bahamas. It is true that little by little they're leaving the so-called tax havens because they're being scrutinized more and more. Our island, so is also quite common. Important cases and very knowledgeable cases, obviously Google. Why do people go to holdcos in tax favorable jurisdictions? Switzerland to a certain point in certain cantons also. It's the famous problems with transfer pricing. So if I have my holdco is in Ireland and I'm taxed at 10%, but the activities are being carried in UK and US, and that the tax in US is 21% and in UK, I don't remember now what is the corporate tax, I have it somewhere here. So UK is 19% and US is 21% plus the state. So the state has a little bit there. For example, Delaware doesn't have it, so it's a lower tax. If you have your holdco in Ireland and it's taxed at 10%, and you have your US subco and your UK subco with your hotels at 21 and 19, obviously you want to try to take the profits up to Ireland and be taxed at 10% instead of 1921 because you're saving 9% or 11%. This is called transfer pricing. Basically, you're taking profits of or the BEPS, which is the profit, the base erosion. You're taking the profit from a jurisdiction of a higher tax jurisdiction to a lower tax jurisdiction. This is why all the OECD countries, at least because following OECD rules, have applied transfer pricing rules. This basically means that related parties, which would be holdco in this case, and the UK and US corporations, need to have a relationship in an arm's length basis, which means if I am carrying out 80% of the job, I should have 80% of the profits. I can't take 100% or 90% of the profits to Ireland. If UK is doing 30% of the job and US is doing 60%, profit should be transferred, allocated in that manner, and tax should be allocated in that manner. There's several rules of transfer pricing. The main ones is what your competitors' margin is, what your competitors' prices and margin and benefits are. So you should be having the same profits. The second, and then there's a little based on this one, more complex. Of where is the margin, where is my competitors of my subsidiary of the chain of value, but it basically is that how is that profit shared in normal conditions without related parties. And the second one, which usually is, for example, for big corporations, etc., which are not necessarily competing against another and taking all the profits, but all the work is done and you can't really allocate. For example, if my our UK and US conglomerate has their human resources in Ireland, it has their call center in India. So what you need to look at is how are the different factors distributed. The risk factors, so who has the liabilities, who has the contracts, etc. Who has the assets? Where are the actual assets, and where is the activity carried out? So those three things need to be seen where they are just how they're distributed, and the profits needs to be distributed. That is a very complex, and you need to get your accountants, and it's obviously a very subjective also. But it's a process that's to be done. Companies, usually big companies as such, they get a transfer pricing report, which is based on a program. There's specialized programs on this and analysis and etc. And you have that transfer pricing like a certificate basically, and you're more or less covered in that sense. But this, for any big company with a subcos and corporate group, is something that they need to take into account. Carrying on a little bit with the UK and US corporate tax on a more general level, Corporate tax in UK is 90%, US is 21% plus the state. So usually it's a little bit more. It depends on the state. Delaware, as I just said, that is why people say Delaware is a tax haven, but it really isn't. You're paying 21%. And then the good thing, or what is attractive about Delaware, is the privacy of its shareholders, most than its tax. Very important also, and one thing that people don't take into account for the US has a substantial foreign earned income credit. So there was, for example, an important study done by KPMG in 2019, last year, that the effective tax rate, because after Trump lowered taxes, the effective tax rate of US corporate was one of the lowest in civilized developed countries, because when the companies apply that US foreign earned income exclusion, which also is in the personal income, by the way, the effective tax rate is very low. So that was a way to attract corporations back to the US. I think this more or less covers the main points about the taxes. Oh, one last thing that companies do take into account, which also comes into collision with what James was talking about. If you're transferring the shares, you can transfer the losses of the company if it has the tax credit and the carry loss forwards. If you're transferring the assets, no. So if you're acquiring, I don't know, a very high-tech company, high value, but big losses, it may as well be a good thing to consider if the company has had a lot of losses, in order to be able to take advantage of that losses and credit it with future gains. That, I think, more or less covers everything. I don't know if you want to carry on.
Well, no, I was just gonna. We've actually had a couple of questions come through. I wonder whether at that juncture it makes sense. Maite has asked about how come Apple is able to do transfer pricing. What type of strategy do they follow? I'll hand that one happily to Lucia to see if she has some thoughts. I doubt she has an inside view on Apple's tax planning, but maybe some ideas.
I would love to have Apple as a client. If they're hearing me, please come to me. But I'm sure they have this very studied with a transfer pricing report, and I'm sure when they have the whole code, which I'm not sure to which it is, I'll look it up. Especially if you register the class, I will have a specific answer to this. But I'm sure they have, like, people now that have the companies that have their holdco in Ireland, etc. They now have offices. They have what is called economic substance, with offices, employees, etc. It's not the bulk, but they do have directors there. They carry out the directors' meeting there, and they have assets and activity, and anything that doesn't require actual expenditure, or for example, employees, pension plans, etc., like which can be IP, can be a contract, are usually done with there. And then you're carrying out the risks and liabilities, and asset IP, for example, which is an asset, can be registered there, which doesn't require a lot of human capital.
Yeah. So hopefully that covers your question, Maite. So and Clara had another question about Brexit. I've spent 4 years being depressed about Brexit, so thank you, Clara, for raising it. I joke, of course, not really. So Clara asks, do you think that Brexit will have negative effects on the choice of companies or businesses to establish in the UK? I think Brexit will have many negative implications for the UK. I think so. There are two separate strands to that question. I suppose the idea of actually establishing a company in the UK, as for the reasons Lucia's just gone through very thoroughly, I think most of the actual establishment of a kind of a company that is, you know, an operational group in a group of companies will not be established or registered in the UK. It might have subsidiaries in the UK, but its kind of holding or parent company will probably be in Jersey or Guernsey or the Cayman Islands or the BVI. But I think in terms of actually establishing businesses and having an active presence, I'm sure it will have an impact. That's because of a multitude of factors that don't just relate to corporate law and taxation, but also relate to visas for employees and various other reasons. So I think Brexit is absolutely something I'm happy to discuss on the course, not least because by that point the UK will have actually left. We'll have finished the transition period. But it's a very good question, Clara, that I wish I could answer. But seeing as Boris Johnson and his cabinet probably wouldn't be able to answer that question, I'm afraid I can't tell you much more at this stage, but something we'll definitely address on the course because it's an interesting topic. Hopefully that answers your question, Gladys, for at least for now.
To be honest, I'm just going to jump in there. I've had a lot of clients that are actually looking to the UK for buying, first because they think everything is gonna, the prices are gonna lower, establish a company and like buy a house, etc. But also looking to establish a bank account, because once they're out of the European Union, they're not subject to European Union regulation, compliance, etc. So I think it actually, obviously, in the general terms, I don't think it's going to be extremely beneficial. Again, you never know. But I do think it may attract some kind of business that is looking for more flexible operations, not necessarily strange or etc. But it is true that the European Union is very regulated, and it sometimes becomes too bureaucratic.
Do you think that's more of a question for like wealthy individuals investing or corporates? I think it's both.
I think both.
Yeah.
Like, to be honest, yes.
Okay. Because I mean, London. Well, what is certainly true is that London itself has always been a massively attractive market for investment in property. For example, there's much Russian, Middle Eastern, and Chinese investment in real estate in London, of course. And those groups often operate not as individuals, but rather as investment, property investment companies. So, yeah, I mean that's a very good point and a potential positive. So I appreciate you raising it.
I'm sorry.
Foreign investment will perhaps go up. So, so I don't know what a bit. I think we have employees just and then I'll move on to antitrust. Yeah. And please do keep the questions coming if you have if any occur to you.
Yeah, it makes it more amenable,
interactive as well. Yeah.
So I'm gonna talk very briefly about employment, because I did mostly tax, which is the thing I love. So, and we're running out of time. But employees, basically, we need to take into account US and UK are super different in the employee regulation. US has a lot less protection to employees, while the UK has a lot more employee protection rights, the regulations, etc. So in general terms, again, UK is quite similar to, for example, Spain. If you buy the shares of a company, you don't need the approval of an employee. You can go ahead and do it. But employees obviously remain with the same, well, obviously for us maybe, but not for the US, remain with the same rights, contracts, time, pensions, etc. So that is one thing actually it's very looked into. What type of liability you're acquiring when you're acquiring employees, and if you fire them, what type of indemnizations do I have to give them, because the new company acquires everything and it carries on as usual. In the US, it's a lot more flexible. In general, they can more or less pick the people they want to transfer and the other ones not, and protections and rights are a lot less. Once the M&A process, what usually is done, you take a list of the employees per se, you check the boxes of the regulations, if they're being the payments done, the payments due, and if there's any judicial process going with an employee. This is usually done, and if not, then within the warranties and indemnification that James is talking about, the company transferring employees usually gives a reps and warranty that there is no risk or no liability coming over that, or try to resolve any historical disputes. In the UK, how do you call syndicatos? No syndicates.
Trade unions.
The trade unions. Sometimes trade unions are involved. Usually, if it's a big company, then you usually have to deal with trade unions and in order to ensure a smooth transaction and that employees' rights are not being violated. I think more or less that is the general terms. I think what you need to stay with is UK, same rights, same protections, transfer of employees, and the US, there's a lot less protection.
Yeah. And I think, I mean, before I move on to the competition, because there's a slightly different element to what we've covered. So I think a lot of this, as lawyers, what you'll be looking at is a thorough, as I mentioned at the start, a due diligence process. Where when I first started training as a lawyer, you literally sat in a room with a load of folders, and you had to go through the corporate documents, the employment contracts. And so you'd have someone from each of your relevant departments, the employment department, the real estate, the tax, and they will all be looking at the relevant documents, making what's called a due diligence report, and setting out all of the potential liabilities that company has that will need to be crossed off, made sure they're accounted for in the sale and purchase agreement and ancillary agreements. So all of the considerations that we've just been discussing should be at the forefront of a lawyer's mind when it comes to that due diligence process. You need to see everything. The seller needs to be open. The buyer needs to be aware, because the caveat emptor principle, buyer beware, applies, and you need to make sure that your client is covered, whether you're the buyer or the seller. So just to come on to an area which is close to my heart as a competition lawyer, but might not apply to or be in the forefront of the mind of the client, and may not be at the forefront of your minds, depending on whether you've studied competition law before. When a transaction occurs in almost certainly every jurisdiction in Europe and North America, and increasingly Latin America has more and more kind of developed and in-depth competition regimes. I mean, it's always had relatively kind of on-point merger requirements, but increasingly the kind of competition authorities whether it be Asia, Latin America, they're increasingly investing more money in their national competition authorities. So the merger, in the context of Europe, the mergers are governed either by the European Union if the transaction is large enough to basically register or tick the threshold of the European Commission becoming involved. In the UK, it'll be the Competition and Markets Authority, what was previously called the Office of Fair Trade, and has had various kind of iterations over the years. So if we're taking our US company, say it's the size of a hotel group like Marriott. Now Marriott is obviously one of the largest hotel groups in the world, or Hilton, or whichever one you care to think of. If the purchase of that UK hotel group will distort the market in Europe, whether that be just in the UK or in the European Union as a whole, because say for example the UK hotel group has a multitude of hotels throughout the European Union. There may be what is called a triggering of reporting requirements. Now, if this is done on a kind of semi-voluntary basis, because if a merger triggers these thresholds, which are generally done by the turnover of the companies combined, then you need to have in place a reporting process. So the lawyers involved in the deal, the competition lawyers involved in the deal, corporate lawyers will need to say to the client, look, the A plus B turnover in the UK equals, we tick this threshold. Therefore, we need to report our transaction either to the Competition and Markets Authority in the UK or to the European Commission, depending on the size. Now, that involves a big process, again, of due diligence, because you need to figure out how big the company is in the relevant market. Now, that leads to the immediate question, what is the relevant market? Now, you could say, okay, the relevant market is hotels. Well, you need to think, where are the hotels located? What type of hotels are they? I mean, a clever competition lawyer will formulate an argument that says a hotel like the Melia in Plaza de España or on Princesa is not the same as a boutique hotel in Malasaña. So we need to think about what kind of companies, what kind of hotels are these? And is there a market within a market? Because if you can, the idea is to actually make your market as expansive as possible, so that you have as little risk of distorting that market by the transaction that you're taking forward. So again, in the back of your mind, you need to think, what's our joint turnover? What considerations do we have that might lead to this this transaction requiring us to report it to the relevant competition authority? And that involves really quite a complex market study where you are making clever arguments for your clients that mean that you potentially don't need to report it. And if you do need to report it, then you can lead a dialogue with the competition authorities, whether that be the European Commission or at national level, as to why, regardless of the fact that this is triggered, your merger should be ratified and it should go through. Now, if there are competition issues, then the authority can actually outright block a transaction. So if there's going to be a problem with, for example, the creation of a monopoly or other competition issues, then the authority can actually block the merger completely, or it can impose conditions whereby you might have to divest part of the company in order to satisfy the requirements of the competition authority. It might have no problem at all. You might report your transaction, the competition authority looks at it, and it says that's fine, you thank you for reporting it, it goes through. The problem is if you don't report it, then sometimes a competition lawyer will take a risk by advising, well, take a risk strategy with the client and say, look, we don't want to have to report this because it could threaten our transaction, it's going to lead to loads of legal costs, and we're actually just not going to report it because we don't think it's going to be a problem. Now, in those occasions, many companies have fallen foul of these rules over the years by not reporting. The competition authority, whether it be the commission or the national competition authority, gets wind of the transaction and finds those companies and actually requires them to undo their transaction. So these are major issues at stake that need to be thought out in detail at the start of the transaction. That is kind of, in a nutshell, the competition element. As I say, something your client might not necessarily think of, but that you will need to. I think that's all that Lithia and I had to say, unless Lithia, you had any other kind of final comments. I don't know if anyone has any questions, or we can look forward to seeing you all on the course in February. But please let us know. We'll hang on for a second and
obviously, if you have any questions that arise later, I don't know if we can we put them in the chat our emails? I don't know. Anyways, you can at least you can email my email, luciagoy@goygentile.com. Feel free if something hasn't been answered. If you have any questions on the course, of how is it going to go, we are super happy to answer any questions. Encourage you to join. Hopefully, it's going to be a very interactive course. We're going to try to make it practical also. And anyways, thank you so much for your time and your interest.
Yeah,
and have a great afternoon.
Absolutely, and I mean, on the contact point, again, like Lucia, very happy to answer questions. So maybe we can speak to Ignacio and Jose afterwards and have our information sent out to the people who signed up for the session or something like that.
That's more intelligent.
No. Well, I mean, if that's possible, then I think that's the best way to do it in terms of capturing everybody. So thank you very much for attending. We hope you've enjoyed it. Hopefully, it's practical and gives you an idea about the issues on the course. So look forward to seeing you in February.
Thank you. Bye, guys. Have a great afternoon.